Hello, and welcome to Nutshell History. Today, we're going to take a look at the history behind affirmative action. Allons-y! Okay, so it's pretty safe to assume that the concept of affirmative action is not entirely foreign to you. However, the old saying goes that assuming makes well, it's not good to assume. Anyway, affirmative action is when a certain organization adopts a policy where minorities, or otherwise underrepresented populations, are given preferential treatment when it comes to being accepted into a college or getting a job. Although many universities, corporations, and local governments do practice affirmative action, for simplicity's sake, we are going to mainly focus on federal affirmative action, what the national government does. Let's begin in 1954 with Brown versus Board of Education. This decision overturned the previous Supreme Court decision from 1896, Plessy versus Ferguson, which declared racial segregation is fine, so long as it is separate but equal. Yeah, that whole equality thing didn't actually happen. So the justices ruled during Brown versus Board of Ed that Plessy versus Ferguson decision had violated the Equal Protection Clause of the 14th Amendment because, let's face it, although white and black schools were very, very separate, they were anything but equal. So Brown versus Board of Education meant that schools now needed to integrate with all deliberate speed. Now let's fast forward a couple years to Kennedy's presidency. In 1961, he signed U.S. Executive Order 10925, which states that it is the obligation of the United States government to promote and ensure equal opportunity for all qualified persons without regard to race, creed, color, or national origin, employed or seeking employment with the federal government and on government contracts. Phew. So if you receive any federal funding, for example, the military, public schools, or if your company does a project for the government, you can no longer discriminate based on race, religion, you get the picture. Which is awesome, but it doesn't guarantee equal treatment. Let's say it's 1962, and you are from the federal government. You are funding a company to complete a certain job. Now, for this job, the company will need to hire 5 new people. They receive 30 applications for these jobs from a diverse pool of people, including men, women, blacks, and whites. From these 30 applications, the company picks 5 white men for the job. Now, perhaps these 5 white men were the most qualified for the position. But if this happens over and over and over again with many different companies, doesn't it start to look a bit suspicious? That's why in 1965, Kennedy's successor, Lyndon B. Johnson, signed U.S. Executive Order 11246, which pretty much instituted affirmative action as we know it. The contractor, that's the military, public school, or any company working for the government, will take affirmative action to ensure that applicants are employed and that employees are treated during employment without regard to their race, color, religion, sex, or national origin. To comply with this order, some institutions and companies then started to apply quotas to their hiring pools. But these quotas can cause some issues. Let's jump to 1978 for the Supreme Court case, Regents of the University of California versus Bakke. The UC Davis Medical School set aside 16 of its 100 seats specifically for minority students. Remember, since we're talking about a public university, it has to uphold affirmative action in order to receive government funding. However, after 33-year-old Alan Bakke, a qualified applicant, received his second rejection from UC Medical School, he sued the university on the grounds that giving preferential treatment to minority candidates who were not as qualified as himself actually violated his rights under the Equal Protection Clause of the 14th Amendment. In the end, UC did away with its quota system, instead taking a more holistic approach, where race could be considered in the application process, but wouldn't be as large of a deciding factor. And now we arrive at the present. At the present time, the Supreme Court is reviewing Fisher versus University of Texas, in which plaintiff Abigail Noel Fisher sued the university for violating the Constitution's requirement of equal protection. UT automatically accepts in-state applicants who placed in the top 10% of their respective high school classes, And although Fisher was ranked just below 10%, she argues that she was more qualified than the minority applicants in 2008, who were accepted into the freshman class. Those of you who use the Idea of America program might recognize that affirmative action shows the tension between the values of freedom and equality. So in helping to promote equality for minorities, does the government unfairly limit the freedom of students like Alan and Abigail? If Johnson's executive order had never been passed, would things have naturally gotten better for minorities or stayed more or less the same? Is the merit of a person really based on their abilities or tied to one's race and gender? Or are all these things all intertwined in a big ball of merity, socioeconomically stuff? What do you think?